Fellow Americans, this week I nominated Neil Gorsuch for the United States Supreme Court. Judge Gorsuch is one of the most qualified people ever to be nominated for this post. He's a graduate of Columbia, Harvard, and Oxford. He's a man of principle. He has an impeccable resume. He's widely respected by everyone. And Judge Gorsuch's proven track record upholding the Constitution makes him the ideal person to fill the vacancy left by the late, great Antonin Scalia, a truly fabulous justice. 10 years ago, the Senate unanimously approved Judge Gorsuch's nomination to serve on the 10th Circuit Court of Appeals. I urge members of both parties to support Judge Gorsuch and, in so doing, to protect our laws and our freedoms. This week, we also took significant action to roll back the massive regulation that is devastating our economy and crippling American companies and jobs. That's why I've issued a new executive order to create a permanent structure of regulatory reduction. This order requires that for every one new regulation, 2 old regulations must, and I mean must, be eliminated. It's out of control. The January employment report shows that the private sector added 237,000 jobs last month. A lot of that has to do with the spirit our country now has. Job growth far surpassed expectations in January, and the labor force participation also grew, so you can be encouraged about the progress of our economy. It's going to be a whole new ballgame. But there is still much work to do, that I can tell you. Also this week, on the first day, Black History Month, I was pleased to host African American leaders at the White House. We're determined to deliver more opportunity, jobs, and safety for the...
Judge James Robart wrote in his order, "The court concludes that the circumstances brought before it today are such that it must intervene to fulfill its constitutional role in our tripart government." The court's intervention was, in effect, to strike down the entirety of the president's executive order. We are joined now by phone by Laurence Tribe, Harvard Law School professor. Professor Tribe, what is your reaction to this opinion tonight?
I think it was historic, and I think it was correct. Clearly, the administration has a different view, but I think when the dust settles, even a 9-member Supreme Court that included Neil Gorsuch, if that's the way it turned out, would agree that this order on its face is lawless. It violates due process. It's religious discrimination, thinly disguised in violation of the Establishment Clause. It has numerous infirmities as a matter of Fifth Amendment due process. And what's really striking about the order is a couple of things that I think haven't yet been mentioned. One is that the court recognized that the states have standing on behalf of their citizens, and in particular on behalf of their universities, state universities in particular, because of the way in which the sweeping blacklist of people from 7 designated countries prevents individuals from returning to the United States with visas that had otherwise been issued. That's important partly because it recognizes the standing of state attorneys general in a context where that's in part a question of first impression, although the Texas court that stayed the DACA order by Barack Obama took a similar approach. It's also extraordinarily important to note that the government's cancellation of 60 to 100,000 visas in the dark of night, as it were, secretly, while litigation was being mounted in behalf of people who were being detained or sent back to their countries of origin, was something that was done basically behind the backs of the courts. And now the question is, in what way can this order effectively resurrect visas that essentially were killed by the Trump administration? On the one hand, it's possible to understand this order as automatically bringing back to life those visas. On the other hand, if you're one of the people who wants to come back to the United States and you have a visa that the government told you it had canceled, you may be in something of a quandary, and something must be done to clarify the situation in order to give the decision of this court its full human impact.
Professor, I really want to go back over this one point because it's so unprecedented in my experience from where I sit, and that is we have a group of cases ongoing in federal court being brought in different jurisdictions, first Brooklyn, then Boston, then Virginia, Seattle, Los Angeles. They are about visas. That's part of the evidentiary base of the case. And
right.
Secretly, unbeknownst to any of the judges in any of those cases, the government, which is a party to the case, reaches into the evidence of the case and changes the evidence, in effect, by revoking these visas. I can't think of anything like that, that a party like the federal government in cases like this would even conceive of doing under the watch of a judge.
Well, it would be very much as though President Nixon had decided to burn the tapes while his lawyer was arguing that he had a right not to reveal them. You know, we have had examples of gangsters destroying evidence while the government is trying to pursue them, but usually they don't occupy the Oval Office. It's really quite remarkable. I guess we'll soon be asking, what did the president know, and when did he know it? Was it Bannon? Who was it that directed all of this to happen? We didn't yet have a full Secretary of State representing the administration, although I'd have to go back to the chronology to see when Tillerson was actually confirmed and when some of this happened. It's all happening so fast that I have to confess I'm losing track a little bit of who was on first and who was on second. But it'll all get straightened out, and it'll get straightened out in a way that I cannot imagine makes this administration look anything other than lawless.
Professor, it looks like in the chronology as we have it now that those visas were revoked before Rex Tillerson took the oath of office. They were revoked around Monday, possibly. But you're right. We're going to get the autopsy on that and see very clearly who reached into the State Department and ordered that to happen. When President Trump was inaugurated, there was a lot of talk among, say, states like California, the Attorney General of California saying, the states are going to be the resistance, the Attorney General of the state of New York saying that the attorney generals would be the resistance against this president. For a lot of us non-lawyers, it wasn't easy to understand what that meant. I think to you constitutional scholars, it seemed clear. But now, tonight, we are seeing what that kind of legal resistance can mean.
Lawrence, if I can interrupt for a second, this is only the first of many such events. I mean, take the sanctuary city situation, where it looks like the president is trying to yank money from states and cities that don't submit to the attempt on its part to discover all of the undocumented immigrants and potentially deport them. When states and cities say, you can't make us affirmatively cooperate, you can't commandeer us under threat of taking all our money away, they are invoking classic states' rights jurisprudence of a sort that used to be the favorite of the conservatives. I think we're going to learn that states' rights can be part of a democracy, sort of part of an experiment in liberty and equality as well.
Professor Laurence Tribe, thank you very much for joining us tonight on this historic night in the middle of these amazing cases. Really appreciate you joining us.
Well, thank you for calling, Lawrence.
Thanks. Tonight's ruling is a huge victory for the ACLU, which has been in there in these courts fighting these cases around the country. We're joined now by phone by Anthony Romero, the executive director of the ACLU. Mr. Romero, did you expect that Seattle was going to be the place where the most sweeping blanket ruling would finally be issued, and one that, as far as we can tell tonight, is being accepted and now, most importantly, enforced by the administration?
It's wonderful. It's wonderful. The leadership from the Attorney General in Washington State, joined by his colleagues in Minnesota, really is significant for the litigation, not just out of that state, but for across the country. We have 4 lawsuits in various jurisdictions looking at the Muslim ban. And no one ever knows. We may have filed the first one, but we never know which is the first one to really register on the merits, or nor will we know which one is ultimately the one to go before the Supreme Court. Well, what is clear is that we're going to need this volume of litigation in many jurisdictions to keep the pressure on the Trump administration. And so the fact that attorneys general are jumping in, the fact that there are other public interest law groups like the National Immigration Law Center and the ACLU bringing these cases, I think really serves us, because ultimately, clearly, the law is on our side. And the more that we can rob the Trump administration of momentum and ball them up in court and pepper them with these lawsuits as often as we can, the less likely they'll have the energy to implement the orders.
And one thing we've seen in the sequence of these judicial rulings is the first one in Brooklyn was relatively narrow. The next one in Boston seemed a little bit broader. The Los Angeles ruling seemed to be the broadest ruling of all,
Yep.
but then it ran into enforcement difficulties. And then finally, Seattle becomes the blanket ruling that is very clearly directed by the judge to cover all 50 states. And you have to wonder, how much did the judge in Seattle, being the last one to rule in this sequence, benefit from being able to see all these previous incremental rulings leading up to his?
And I think then the judges in other jurisdictions will leapfrog off of the decision in Seattle. As other judges rule, they'll get comfort from the ruling in Seattle. And I think we'll likely to see the jurisprudence evolve. The public opinion is certainly on our side. Already there are Republican members of the Senate who are saying that the ban is not just un-American, but it's also unconstitutional. And so we need to put as much wood on this fire as we possibly can to make sure that this ban is not implemented and it continues to be struck down.
And have you ever seen, I want to go back to this point we talked about with Professor Tribe, have you ever seen a situation where the government in a case like this, the U.S. attorneys, would be a party to a situation where a branch of the government would in effect destroy the evidence in the case by revoking these visas, the pending visas of the people whose rights were being argued for in these courts?
Sure, we saw it in the Bush years.
I want to read you what our Pete Williams is just now reporting. He is reporting that a Department of Homeland Security official is saying that the Seattle judge's order will have no immediate practical effect. The official from the Trump administration is saying all previously issued visas from the 7 affected countries were canceled by last week's executive order. So anyone hoping to come to the U.S. from those countries would have to go to consular offices and reapply for a visa. And in the meantime, the Trump administration is likely to seek a stay of today's order. Can you make sense of that for us?
Yeah, I'm not sure. Thanks, first of all, for having me on. I really appreciate it. And I'm not sure if I can make sense of the first part of that. What I can say in general, at a high level, is that the judge's decision here today was very clear, that he said that he granted a temporary restraining order that has effect nationwide, essentially nullifying President Trump's executive order. So it allows people now to travel to our country if there are specific visas they need to obtain. I can't get to that level of detail. I don't have that information.
Sure.
But at a high level, the judge's decision essentially strikes it down as a temporary restraining order until he has a chance to weigh in on the issue on its merits.
And one of the things that has been confusing when it comes to the Trump administration is whether or not it's clear that they're willing to abide by these kinds of orders. You have the Department of Homeland Security sounding at least as if they are sort of refuting what's in this judge's order. What would happen then if people are getting off planes now subject to this stay and are still stopped from coming into the country? What sort of relief could they have now that this judge's order has come down?
Sure, I don't want to be overly dramatic, Joy, but you would have a constitutional crisis. We are a nation of laws, and that applies to everybody, including the President of the United States. And in a courtroom, it is not the loudest voice that prevails, it's the Constitution. And it is certainly my expectation as the Attorney General for the state of Washington that the federal government, including the President, will obey and follow the order of Judge Robart. I understand they may not like it, and they have rights to appeal it, which they're certainly entitled to. They will lose, but they're entitled to appeal. But It is their obligation and responsibility to the people of our country to follow and uphold the rule of law.
And if you, sir, could, we're speaking, by the way, with Attorney General Bob Ferguson, the Washington State Attorney General. Washington and Minnesota filed this lawsuit, which has now resulted in a Washington State judge issuing a temporary nationwide restraining order, which immediately halts the enforcement of the Trump administration's travel ban to the United States. If you could just briefly, sort of in lay terms, if you could, walk us through the argument that was made by yourself and your fellow AG from Minnesota that wound up prevailing in this case. Why, in your view, is this travel ban not lawful?
You bet. So the arguments in court were made by my Solicitor General, Noah Purcell, and the Judge Robart, was very thoughtful. He asked difficult questions of both the federal government and of my Solicitor General, Noah Purcell. In essence, the judge went to a couple key issues. He wanted to know, the federal government, for example, had argued that as Attorney General, the state of Washington did not have what we call standing to be in court. In other words, that we did not have a dog in the fight, that we could not bring this action. And there was a fair amount of time spent on that issue. The judge made it very clear in his ruling that the state of Washington did have standing, that we could bring this claim. And in order to grant a temporary restraining order, Joy, a judge, it's a tough burden to meet for obvious reasons. You're shutting down this entire executive action by a president, so it's not easy to have a judge give you that relief. One thing the judge has to decide is that it is likely that the state will ultimately prevail on the merits of our claims. In order to grant that restraining order, the judge has to conclude that we're likely to win when he gets to the merits, and the judge reached that decision, as well as he said, it's in the public interest, another standard he must review for this executive order to be struck down on this restraining order until he has a chance to rule on the merits.
All right, got it. And now I want to really quickly play something that the Solicitor General said today about the Justice Department's argument. Please take a listen, sir.
I did say at one point that the Department of Justice's argument was frightening, and the argument was essentially that if the president says, I'm doing this in the national security interest, then a court cannot review whether that's the real reason or whether there's even any rational reason for the president's action. And our view is that's not the law. That's a scary view of the law, and luckily the judge rejected that idea.
And Attorney General Ferguson, why in the view of your Solicitor General, is that a frightening argument?
Well, I was proud of Noah for saying it, because that was part of the federal government's argument is a court cannot look behind an executive order. In other words, trust us. National security, judge, you cannot take a look at it and what really is motivating that executive order. You can't look at whether it favors one religion over another. You can't do that. And that cannot be the rule of law in our country. We've been through too many experiences in our country to know better, that you have to have everybody be under the rule of law, and that includes presidents. And to have that check and balance system in our system of government is critical. And so, frankly, Noah Purcell, my Solicitor General, he got it right. That is frightening and should be frightening to the people of our country, to think that somehow a court cannot review an action taken by a president. Is there deference given to a president when he or she executes an executive order? Yes, of course, but that does not mean that there can be no scrutiny at all, and Judge Robart got it right from that standpoint.
And quickly, how important to your argument was the fact that it did seem that the administration was trying to create a carve-out for people from, quote, minority religions from these countries, meaning, you know, if you sort of go to the logical argument that Christians from these countries would be able to come in, and how would they even determine that?
Right, those are all good points. The judge did not need to address the specific grounds in which he concluded that we are likely to prevail on the merits. He gave a oral ruling at the end of the oral arguments, Joy. He'll give a written opinion later on that I suspect will lay out in more detail which arguments persuaded him on those points. So I would not be able to state with any certainty what it was about our arguments that actually moved the judge on our specific claims.
So you, one of the other things that you said in your press conference today was that you said the administration were, in your words, Keystone Cops. Can you explain to us what you meant by that?
Well, look, and those aren't just my words. I mean, I think Republican leaders in Congress, in the Senate and Congress, have made it clear that this was not a thoughtful process in writing and executing this executive order, which is, frankly, deeply troubling when the broad strokes and the impacts of that executive order impact so many people and their lives in a fundamental way, not just people in my state, but also businesses in my state. It's the reason why entities like Expedia and Amazon wrote declarations last weekend so we could file them with our complaint on Monday, because they wrote about the impact on their employees, the impact on their business as a result of this executive order. It was not well thought out. I think virtually everybody agrees with that, and that did not help the government's case today.
All right. Well, Attorney General for Washington State, Bob Ferguson, thank you so much for taking the time.
Thank you. You have a great night.
Thank you.
A CBS News poll out this morning finds President Trump has a historically low job approval rating. 40% of Americans approve of his performance after 2 weeks in office. 48% disapprove. The split is largely down party lines. No other president in polling history, going back to 1953, has had such a poor approval rating this early. The poll also finds Americans narrowly disapprove of the president's order, temporarily blocking people from 7 Muslim-majority countries from entering the U.S. Nancy Cordes is on Capitol Hill as the president gets ready to launch 2 executive actions that will affect Wall Street. Nancy, good morning.
Good morning, and these executive actions are going to thrill congressional Republicans who have long wanted to roll back what they say are burdensome regulations within the Dodd-Frank Act. Democrats, meanwhile, say that those regulations are in place to prevent another financial collapse like the ones we saw in 2007 and 2008. Dodd-Frank was signed into law by President Obama back in 2010. It created a consumer protection agency, and it reined in some mortgage practices and trading that led to the collapse. Senior White House officials, though, say that this executive order is going to direct the Treasury Secretary to review Dodd-Frank and make recommendations about how to change or unwind it. The president described his intentions on Monday during a meeting with small business owners.
Dodd-Frank is a disaster. We're going to be doing a big number on Dodd-Frank.
President Trump's other executive action will halt new fiduciary rules that were set to go into effect in April, meant to crack down on payments and hidden fees from financial planners. Again, Democrats say those rules were there to protect consumers. Republicans say they hurt competition. President Trump's choice for Treasury Secretary is Steve Mnuchin. He has made stripping down Dodd-Frank one of his top priorities. He's expected to be confirmed within the next week or two, and Republicans are so intent on stripping it down as well that the Senate has already voted just this morning, Anthony, to do away with a key regulation buried in Dodd-Frank.
Nancy Cordes, thanks, Nancy.